I don't remember. I mean,
but
we've had so many cases. I don't.
But I'm on, but we're gonna reapproach.
I'm happy to hear.
So the only question, I do have a question though. So if I have a client that has a fugitive warrant, the other court controls their court date, or does this court?
No. So is he on docket today?
No.
So what happens if someone has an open case elsewhere?
Okay.
And they've not made bond on that case?
Okay.
This fugitive case is put on hold. It's told until they either make bond on the case upstairs or they dispose of it somehow. They plead or it gets dismissed.
Okay.
Then if they have waived here, the 14 days starts running. If they have not waived, then we need to bring them back to do all the, either the waiver, either a bond, or we get a governor's warrant.
Got it. Okay.
The governor's warrant takes another 90 days. So do you know, have they made bond? Is it a felony case?
Well, he made bond on his felony case.
He made bond.
The case is out of Maryland.
Right, but
He made a bond on his, yeah.
Did he refuse here?
No.
He waived? Mm-hmm. So the 14 days has started ticking already from the day that he made bond. So if it's been like a week, he probably has some time under his belt. I don't know.
Okay.
But
it's back on your docket next week.
okay.
So we'll just
if you want to move it up,
okay.
Can, but we got to let Day know. Mr. Kim, you know Day? Kim?
Oh yeah, I do.
Let him know.
Okay.
Rope him in and then I'll do whatever you want to do. If you want to do it again, we can do it again, but I mean, no promises, right?
Thank you so much. Thank you.
Sure. Mr. Alexander?
Yes, Judge.
Okay. Good morning, Mr. Alexander.
We're in front of you today on a evading case, Judge. I want to see if you hear PC on this one.
Okay. Oh, he has a fugitive case too.
Yes, that was appointed previously on the fugitive. It's out of Mississippi, but he's got an evading, which we're dealing with today.
Okay, and he's got an open burglary habitation.
Yeah.
Okay, all right, so Mr. Alexander, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On February 20th, 2025, at approximately 1:00 p.m., the officer was conducting a proactive investigation of a burglary of a habitation in Harris County, Texas. The officer was in plain clothes and driving an unmarked police vehicle. The officer saw an individual matching the description of the suspect caught on ring camera burglarizing a house. The individual was later identified as the defendant. The officers observed the defendant crossing a road where no crosswalk was provided. And then the plainclothes officer advised a marked police unit to stop the defendant and ID him for the traffic violations. The officer approached the defendant in the marked police vehicle with emergency lights activated. The defendant noticed the officer and began to run through an apartment complex. The officer drove into the apartment complex and the officer in plain clothes drove into the apartment complex and he was able to cut off the defendant and apprehend him. The defendant evaded for approximately 300
Did he even
yards.
tell him to stop?
So, but he was.
No, we don't work on hunches, right? You can't assume anything.
I'm not, Judge. I'm saying that he saw the emergency lights were activated and he ran away from the police officer.
Did he tell him to stop?
No, Judge.
Yeah, no problem cause.
Thank you, Judge.
Of course. Okay.
On February 21st, 2025, officers observed the defendant run a stop sign at Probable Lane returning into Woodwood, heading north in Harris County, Texas. A traffic stop was conducted. The officer requested identification, and the defendant provided a TDCJ inmate card with the name Dangwin. The officer ran that name and came back to have some multiple City of Houston warrants, so placed the defendant under arrest. At JPC, they fingerprinted him through cases and found that his true identity was Glenn, and that time he had a felony warrant for yes.
Okay. Mr. Nguyen, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please? See if he has a license.
Was not eligible, Your Honor.
Okay. You are not allowed to drive. You do not have a Texas driver license. Do you understand? Unless you have a valid Texas driver license and liability insurance in your name, do not get into a car.
Right from the start, notice how the attorney is unsure about the fugitive warrant process. This is a common confusion. Different courts control different holds. Pay close attention. The judge is about to break it down in plain language.
You will be signing an affidavit with me today promising me you're not going to drive, Mr. Lynn. I don't care what's going on in your life. I don't care if you have to go save someone and get in a car. Do not drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine, not to mention revoking your bond and putting you in jail. Do you understand?
Sorry.
If you want to drive, go get a license, get liability insurance, and then I will happily take this thing off. All I'm asking you to do is follow the law. Do not drive until you get those things and approval from us. That is the only condition that we are going to place on you today, Ms. Nguyen. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Kimberly, and she will tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games or you've taken off, I will issue a warrant. No more PR bonds. You understand?
Yes, sir.
Okay. I'll have you come up here, swear to us that you're not going to drive,
Yes, you've had a surety bond.
and then after that, we'll let you go.
Yeah, surety bond.
Okay, yeah, I mean, and so he also has something upstairs as well. So do you want the same day?
I want to speak for you about that. I think that case will probably resolve this case, so.
Yeah, but we gotta put it in a day. I
I'm
mean,
gonna do the same day, but I think we can shop a little bit later.
it's okay, whatever you want.
Okay.
Okay, Mr. Mooney, come on.
Did you see it? Pleasure
You too?
It's good.
Wonderful. Always good. Four.
Silence the defendant involved.
Thanks. I would have more if I had more money too. I'm just,
Good to see you, right? Good to see you.
you too? Who's junior? And you are? The third. The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, the officer dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incident indicating this was possible burglary in progress, the fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. Commands, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both contained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, Your Honor.
Cops never tell them to stop. And what are they doing wrong? I guess, I mean, what is this, Minority Report? You know what I mean?
Yes, Your Honor. I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand?
Sir.
I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat. Good morning, Miss Mary. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail.
Here comes the key point, the 14-day clock. If the defendant waived extradition, that countdown starts immediately. Have you ever wondered how fast states must act after a waiver?
And or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you then. Okay.
Your Honor, on Sunday, February 23rd, 2025, officers observed a vehicle hit a curb median while traveling eastbound at the 10,500 Alpena Genoa Road in Harris County, Texas. A traffic stop was conducted. The officer smelled a strong odor of an alcoholic beverage on her breath and observed her to have glassy eyes. The defendant admitted to drinking the 1 tequila sunrise alcoholic beverage. SMSTs were conducted. It was a 6 out of 6 on the HPN, but they transported her to JPC for the other test due to rainy weather and the defendant wearing heels. She then at JPC refused the rest of the SMSTs and blood warrants.
Okay. Miss Mary, I'm going to find that there's sufficient probable cause to go forward with the case. Have you run her to see if she has any prior DUIs and if she has a license, please? Miss Mary, I'm going to, like I said, find probable cause. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using either, I will revoke your bond, put you in custody. Do you understand?
He is eligible if he is tested.
Great. As long as you have a valid liability insurance in your name, as well as the license, you may continue to drive. If you do not have either, then you may not drive. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. Don't pick up any new case. All right? For now, I'll have you sign a resale. Victoria will have you get with Felicia. If your bond conditions, then you're free to go. All right.
Thank you.
Thank you. Or Rachel Gutierrez. Ms. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now.
On February 23rd, 2025, at approximately 3 o'clock in the morning, the officer observed a vehicle fail to signal lane changes twice and disregard traffic control devices, changing lanes over solid white lane markers, and then return to the lane it was already in. The temporary tag that the defendant had on her vehicle was expired as of January 17, 2025, and was voided. The officer continued to follow the vehicle, and the vehicle repeatedly failed to drive in a single lane despite another vehicle in front of it. The vehicle was also caught traveling 60 miles per hour in a 50-mile-per-hour zone. A traffic stop was initiated. The officer made contact with the defendant driver, and she was identified by Texas driver's license. The officer observed red, glassy eyes and the odor of alcohol emitting from the defendant's person. The officer also observed the odor of marijuana emitting from the vehicle. The defendant admitted to consuming 2 beers and admitted to smoking a blunt while driving until the officer pulled her over. The defendant stated she was headed north, and she stated she was headed home, but her home was in the opposite direction as she was traveling. SFSTs were conducted. 4 out of 6 clues observed on the HTN, 4 out of 8 clues observed on the walk-in turn, 2 out of 4 clues observed on the one-leg stand. The defendant consented to provide a blood specimen.
Okay. Any prior DWIs and can
No prior DWIs and her driver's license.
Ms. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming either, I will revoke your bond, put you in jail. No more PR bonds.
Okay.
Do you understand? Ma'am, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
Fine.
Okay. Deputy Miranda's going to give you an application. I'll have you fill out an application or sign a receipt. Victoria will get police you for your bond conditions, and then we'll take a look at your application.
Okay.
Please. All right. You are Marcus Leonard.
Yes.
Mr. Leonard, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Just so you know, you're not here alone. Your lawyer is here with you, but on Zoom as opposed to being in person. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay.
On February 21st, 2025, in Harris County, Texas, officers met with the complaining witness as a walk-up.
Hold on a second.
Watch this moment closely. The officer never told the defendant to stop, and that absolutely destroys probable cause for evading. This is why tiny procedural details can flip an entire case.
Not talk. Okay.
Officers met with the complaining witness as a walk-up. Complaining witness stated that on February 19th, 2025, he and the defendant with his father stated that they were discussing who was stronger and that the defendant eventually felt disrespected by this. Complaining witness stated that the defendant then pushed him into a bathtub and then told the complaining witness to leave. And when the complaining witness was grabbing clothes, the defendant pinned the complaining witness and struck him in the eye, causing an orbital fracture.
So it's son. So I see that he's a prior assault. Same complaining witness?
The one from 2008?
Yeah.
No, I don't believe so.
Okay. Have you spoken to the complaining witness in this case?
Yes.
What is his wish?
No comment.
Okay. Did you hear that, Mr. Evans?
Yes, I know Mr. Leonard very well, 20 years. I'm very familiar with the situation, so I understand completely.
All right, so Mr. Leonard, I'm going to find that there is sufficient probable cause to go forward with your case. It appears that a protective order has been issued on the 22nd of this month. I would get to know it. If you do something to violate this protective order, then the state can and probably will file a violation of the protective order. It's one of the worst cases you can pick up. Do you understand? I am also ordering you as a condition of your bond not to have any contact or not to be in possession of weapons. If I find that you have contact with the complaining witness in this case, likewise, I will revoke your bond, put you in jail. No more PR bonds. Now, you've got a great lawyer. Because you have one, I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr. Evans. He'll tell you if and when you have to come back to court. So do you mind filing no contact in the weapons, please? So for now, I'm going to have you go to Victoria, sign a reset. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Do not leave until you sign our bond conditions, though.
Thank you, Judge.
Hold on, I need to get your date.
No, we already got it yesterday.
Oh, you
I
got
came
it?
by yesterday.
All right, have fun, man. Have a good weekend.
Thank you, sir.
All right, Judge, next is page 8. McKelvey,
About your guy,
he hasn't been brought up yet.
still no. Do you think we'll get him?
Maybe,
Are you, can you be here if we don't get him today, can you be here Monday?
Yes, and I think that's what we're anticipating on doing. I talked with the chief, talked with the coroner. I think the plan will be to roll into Monday.
Okay.
And find out. This, you may recall, this is the issue. This had the competency questions. The gentleman who we did competency order, he'd been sent out of state to Louisiana. We did get that back. It had some issues and he was on a 90-day mental health PTI. So there are some issues that I need to see what state he's in. So.
And I just have some concerns now of.
Obviously, because it's number 4.
And if he's not going to be accepting DDRP, I mean, I think it's leaving us with very little options here. And I just can't do conscious.
So you want DDRP?
Well, I don't think DDRP is acceptable.
What do you think?
Well, we did a TRAS before in order to see about that. The TRAS, during the TRAS, they said, well, it's hearing voices, so we can't really continue the TRAS. And then their recommendation was we can't accept them in our DDRP because there's been a history of aggressiveness with the staff. And so we tried to go that route and just didn't find any available kind of resources. And so that's where we thought, well, maybe the best resource is the mental health PTI. And that's where things were at until, at least to my knowledge, until I got that email.
Okay.
Sure.
I guess we'll roll it to Monday, we'll figure out.
Yes, I'll look at it and see.
Yeah, okay.
Okay, thank you, Judge.
Thanks, Branch. You were Miss McKelvey.
Yes, sir.
Miss McKelvey, you're charged with driving while intoxicated. You were facing.
This is wild. The judge is basically saying you can't arrest people based on hunches. Ever seen a judge shut down PC this fast? Let me know in the comments if you think the officer overreacted.
Facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
On February 21st, 2025, officers observed a black SUV traveling northbound on the Gulf Freeway at a high rate of speed at 98 miles per hour. The registration was expired as of February 2024. A traffic stop was conducted and the officer detected a strong stand. She consented to breath, which came back to a .139.135.
Can you prior DWIs? You are an NCRC, please.
Yes, Your Honor. There's no prior DWIs. There are a couple of theft convictions.
And license, please.
Her license now.
Ms. McKelvey, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or any illegal substances like marijuana, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
If you do not have a valid Texas driver license and a liability insurance, then you're not allowed to drive as well. That is also a bond condition.
This part hits hard. The judge gives the 18-year-old a speech most adults need to hear: convictions follow you forever. This is a rare moment of real human advice in a courtroom.
Of yours.
Yeah.
Okay. Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I'm gonna hire one.
Okay. I'm going to have you get a Victoria sign a reset. You will get with Felicia for your bond conditions, and after that, you'll be free to go now.
Okay.
Good
Are
morning.
you signing? This is Mr. Mendoza?
Yes, Joe. And you should have a attorney appearance on file.
Let's see. I got it. You are Mr. Mendoza. Sir, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On February 23rd, 2025, officer observed the defendant fail to stop at his designated stopping point in Harris County, Texas. The defendant was driving and stopped after the white stop line at the intersection when the traffic light was red. The defendant almost crashed into another vehicle before stopping, so a traffic stop was initiated. While the defendant was stopping, he ran into a chain link barrier that was blocking a private property. The defendant, the driver, was identified by his Texas driver's license and stated that he was coming from his sister's residence. The officer observed the defendant to have bloodshot eyes, slurred speech, and odor of an alcoholic beverage. The officer asked the defendant to exit the vehicle, and the officer observed him to be unsteady on his feet. The HGN was a 6 out of 6. The defendant was then detained. He advised that he had a handgun under the middle console. The SFSTs were conducted at the Intoxication room, which was a 5 out of 8 on the walk and turn and a 2 out of 4 on the one leg stand. The DIC was read and he consented to breath, which came back to a .150 and a .145.
Okay. Any prior DWIs, and does he have a license?
In your honor.
Yeah.
And his driver's license is eligible.
Okay. Mr. Mendoza, I'm going to find that there's sufficient probable.
Another DWI, another strict bond warning. Notice how consistent the judge is: alcohol, drugs, driving restrictions, and accountability. Same structure, but tailored to each defendant.
To go forward with the case, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand? Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria, sign a reset. You'll get with Felicia for your bond conditions, and then you're free to go.
No weapons?
Yeah, I guess so. Right.
Thank you, Your Honor.
Okay.
May I be
Thanks,
excused?
guys. Yes, ma'am. Ms. Rios, more. So you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Your Honor. On February 20th, 2025, officers were dispatched regarding a DWI at the 14,700 block of Wallaceville Drive in Harris County, Texas. The officer observed the black Dodge Charger parked at an intersection when the light was green for motorbike vehicles to proceed forward. The officer utilized his horn to get the driver's attention, but did not get a response. He then made contact with the defendant, who was the driver and sole occupant, and observed the defendant to be asleep while the motor vehicle was operational at the time of the offense while his foot was on the brake. The officers were able to open the motor vehicle through the front passenger door to turn off the car and observed red bloodshot eyes, slurred speech, a strong odor of alcoholic beverage, and chunks of vomit on the defendant's shirt. The defendant denied consuming any alcoholic beverages and stated that he was coming home from work. The SFSTs were conducted. It was a 6 out of 6 on the HGM, a 3 out of 8 on the walking turret, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results are a .140 and a .141. He was identified by his driver's license.
Got it. Any other prior DWIs and license?
No prior DWIs and his license is eligible.
Got it. All right, Mr. Rios, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you, as a condition of your bond, not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming any, I will revoke your bond, put you in jail, no more PR bonds. Do you understand? Yes, sir. Now, because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you, you pick up a new case, you're a danger to my community, I only have one place for you. Do you understand? Yes, sir. For now, I'll have you go to Victoria, sign a reset. We'll have you get with Fleischer for your bond conditions, and after that, you're free to go.
Thank you. I'm ready to accept that.
Yes, ma'am. You're Ms. Torres Rodriguez. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to be silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you there.
On Saturday, February 22nd, 2025, officers were dispatched to a theft call for service at the target at 22165 FM 529 in Harris County, Texas. The LPO advised that the defendant was observed on video placing items in her shopping cart. She then went to a different aisle and began placing those items in her purse. The defendant then exited the store past all points of sale with those unpaid items inside of her purse. The reportee then escorted the defendant back into the store and had the defendant empty the stolen merchandise from her purse. The total value of the item stolen was $469.92.
Got it. Okay, Ms. Torres, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any target whatsoever for any reason. You understand? If I find that you go to a target or if you pick up a new case, I will revoke your bond, put you in jail, no more PR bonds. You understand? Do you mind filing that, not going to any target, please? Do you have the ability to hire a lawyer, ma'am? Would you like to apply for a court-appointed lawyer? Or what would you like to do?
I can hear.
Okay, I'll have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box while we'll get your bond conditions. We'll have you sign it, and after that, you'll be free to go.